How long will Ripple's lawsuit against the SEC last? Which new Ripple partner will be able to influence the situation in court? We will answer these questions in today's video. The cryptocurrency industry is waiting with bated breath for the summary ruling in the ongoing legal conflict between Ripple and the Securities and Exchange Commission, SEC. As a result, there's been a great deal of attention and discussion about the case and its potential effects on the regulation of digital assets in the United States. In light of this, the SEC has increased its regulatory control of the cryptocurrency sector in the last week, prompting strong criticism from certain industry players who fear the agency's approach may be biased. U.S. defense attorney and frequent commenter on the Ripple and SEC cases James Filan has renewed his request for SEC Chairman Gary Gensler to step down, following the SEC's crackdown on staking. Paxos, a cryptocurrency startup, is being sued by the SEC on the issue of its Binance USD stablecoin. The regulator has determined that the stablecoin is a security that was issued in violation of the law. It's important to remember that the SEC is also suing Ripple for offering XRP tokens as unregistered securities. In this passage, attorney John Deaton for the XRP holders in the SEC action criticized the deceptive nature of the securities classification. Most cryptocurrencies are deemed securities by Gary Gensler and the SEC, who maintain a singular emphasis on the token. Tokens are not securities, but the issue is that important and knowledgeable individuals are spreading the false narrative that they are. Deaton also praised Coinbase CEO Brian Armstrong for his statement that the company's staking services do not constitute securities. Meanwhile, Deaton has joined another class action complaint against Ripple in which investors accuse the firm and its CCO, Brad Garlinghouse of Marketing's RP, as an unregistered securities and demand compensation for their losses. For their part, the plaintiffs have asked the court to label XRP a security. Deaton has decided to file an amicus brief in this matter. Ripple's general counsel, Stuart Alderoty, has called the SEC's handling of the lawsuit against the company misguided. As with the SEC, Deaton called their reasoning inconsistent and schizophrenic when it came to the idea of a common industry. He further noted that the court has the option to rule against a summary judgment. In addition, the crypto community has been following the dispute between the SEC and the blockchain-based sharing platform Elbri with great interest, despite the fact that the final decision of the case is still up for debate. In this case, the SEC filed a lawsuit against Elbri because the company was selling LBC tokens without first registering with the SEC. The court, however, determined that LBC tokens are only securities when sold directly to the public. After the verdict in favor of Elbri, calls for the relisting of XRP have increased. Particularly, XRP supporters have been petitioning Coinbase and Binance Us to bring back the coin. With more and more people getting behind this cause, it makes you wonder whether they'll be able to get the exchanges to relist XRP. The SEC case is still underway, and it is unknown whether the regulator would push out the timeframe for a summary judgment over the currently projected date of March 2023. Even though the company's future is clouded by legal ambiguity in the United States, Ripple has continued its rapid expansion in other countries. David Schwartz, Ecto of Ripple, has become a Twitter sensation. The Ripple executive and XRP ledger developer made a remark about urinating in a pool in a tweet yesterday, prompting the reaction. Schwartz writes, "I was informed that as long as nobody is really near to you in a pool full of people, nobody would know that you did. I see now that this holds true only if you are in the pool." The crypto and XRP communities have responded in droves to the humorous tweet. It has been speculated by a few Twitter users that the Ripple executive's message may have some hidden significance. As a result, there have been attempts to establish connections to sources of liquidity. Unfortunately, there seem to be no such obvious links. Note that, as was previously reported, XRP ledger engineers are now testing a native automated market maker, AM. Schwartz claims the AM's features, such as facilitating single-side liquidity provision, set it apart from other similar products. In contrast, those who found the joke funny but who didn't interpret any deeper significance posted anecdotes and memes as responses. Even yet, it's worth noting that the tweet has earned praise from an unlikely source, Cardano creator Charles Hoskinson. We should also note that Hoskinson's relationship with the XRP is tense. Notably, He has been at conflict with the community in the past due to remarks he made about the purported settlement date for Ripple and comments he made regarding the links between officials at the U.S. Securities and Exchange Commission and Ethereum. Due to the poisonous and petty nature of the XRP community, Hoskinson said in December that he would no longer be making any more comments on the subject. Furthermore, he said that he had no qualms about severing ties with the community since XRP had no technical or business value. Recently, Ripple to David Schwartz and Bitcoin advocate Tuur Demeester had a Twitter debate over whether or not Ethereum IU was superior than Microsoft and Swift shares. Demeester sparked the discussion with a tweet regarding the Howey test, a legal standard for determining whether or not a certain investment becomes a security. Demeester argued that ETH passes the Howey test because it is a pooled investment in which the returns depend on the efforts of others. I don't understand what you're saying precisely, Schwartz said. You're claiming that ETH represents a joint financial investment in a shared venture. They got their ETH straight from ETH, you say? Layton's attorney Carl Cecere filed a request Monday to ask the court for access to William Hinman's 2018 controversial speech drafts. Layton's attorney challenges the SEC's latest attempt to seal Hinman's speech papers. On December 22, 2022, the SEC attempted to seal certain Hinman speech document records to support its summary judgment request. Ripple opposed Hinman's contentious speech materials, which the SEC attempted to seal. Layton denounces the SEC's move. The Forbes senior contributor wrote several op-eds regarding the papers and their importance to the case while having no financial stake in XRP or Ripple. Layton has written several op-eds criticizing the SEC for utilizing its regulatory authority to choose Bitcoin winners. Layton has authored multiple pieces regarding the cryptocurrency trial of the Century Ripple case. She published another attack on the SEC for treating Ripple and Ethereum differently hours after the motion. As predicted, Forbes removed the item soon after. Cryptocurrency enthusiasts have reacted differently to Layton's move. Pro-XRP lawyer John Deaton tweeted his support for Cecere and Layton's court case for Hinman's records. Hinman's records include emails and other SEC internal contacts related to his contentious 2018 speech draft. The public hasn't seen the materials the SEC gave Ripple in October. Attorney Deaton justified the document's non-publication last year. Deaton said a protective order prevents parties from disclosing the paper's contents. Forbes removed Dr. Rosalind Layton's piece criticizing the U.S. Securities and Exchange Commission's handling of blockchain payments provider Ripple. A pop-up editor notice states this page is no longer active, blocking the article Why the SEC Treats Ripple and Ethereum Differently. The Crypto Basic was able to read the post when XRP community members uploaded images showing that it is still visible in reader mode on certain browsers. Dr. Layton concerns why the SEC grants Ethereum a pass via the contentious 2018 Bill Hinman speech, which it argues is appropriate direction for the nascent sector, yet treats Ripple and XRP differently. The policy scholar who calls this an inconsistency in rules suggests the fiercely debated Hinman papers may be the issue. Emails and other materials planned in the contentious speech are among the Hinman archives. The SEC first blocked Ripple's access to the speech materials in its lawsuit against Ripple. The SEC ultimately gave Ripple the records last October following 6 court orders, but omnibus petitions filed last December aimed to seal them. It reiterated that these discussions are protected by attorney-client confidentiality and that releasing them to the public might hinder agency policy making. In her piece, Dr. Layton argued that the SEC's claim that it guides the new market is hard to swallow. These records might explain whether Ethereum's free pass was driven by Hinman's claimed conflict of interest or if regulators' uncertainty could justify industry players' perplexity and Ripple's fair notice justification. Today, she filed a move to unseal the materials. XRP community members are furious that Forbes seems to have removed the story. John Deaton, whose business mentioned the Forbes contributors file, wrote what Forbes previously removed the tech policy contributor piece. However, the author previously requested an edit. Dr. Layton and Forbes have not responded to press inquiries. The Crypto Basic will update this report with comments.